One question stops new inventors in their tracks almost more than any other. They're filling out our intake form for my law firm. They get to the section that asks, who will own this application? And they freeze. They ask me, do I need an LLC before I can file this patent? Or do I need to incorporate first? They're worried that if they don't have a corporate structure right now, they can't protect their idea. Today, I'm going to give you the short answer and then explain the strategy behind it. Hey everyone, I'm Mark Trenner, a patent attorney who's helped both individuals and businesses secure patent protection for their innovations for the past 25 years. The short answer to that question is no, you do not need an LLC or a corporation to file a patent application. In the United States, patent rights actually start with the inventor, the human being who came up with the idea. You can file, prosecute, and be granted a patent entirely in your own name as an individual inventor. Now here's a common trap. An inventor will tell me, well, I don't have an LLC for this invention, but I do have an existing LLC for my graphic design side hustle. Should I just use that? Generally, my advice is no, don't mix the two. You usually don't want liabilities from your graphic design business affecting your patent rights, or vice versa. Keep your assets separate. So if you don't need to file, if you don't need an LLC to file, when should you get an LLC or corporation for your invention? Usually later, I tell people when things get real. Here are 3 reasons you should consider having an LLC or other entity hold your IP rights. 1. Liability. When you actually start manufacturing and selling a product that someone could hurt themselves with, you want that corporate shield to protect your personal assets. 2. Investors. If you plan on bringing in outside money, they're going to require a corporate structure, usually a corporation, so it can issue stock shares. 3. Co-inventors. If there are multiple inventors, a company structure is vital for defining exactly who owns what percentage of the idea. Here's the good news though. You don't have to decide today. Often, the best strategy, assuming you don't already have a business entity for the product, is to just file in your name as an individual right now to get your priority date secured. Later, when you form that company, your patent attorney can file a simple document called an assignment to transfer ownership from you personally into your new company. One important caveat though, I am a patent attorney, not an accountant. There may be tax benefits to having an LLC hold the IP rights to your invention. So always ask your tax advisor about that side of things. But don't let the lack of an LLC stop you from filing for a patent application. Protect the idea first, build the business structure later. If this helped clarify things, please hit the like button and subscribe for more practical patent advice.